This is Michael Cowen, and welcome to Trial Lawyer Nation.
You need to show people the worst possible harm that negligence could have caused, because that's what the case is about.
What I'm asking you to do is to focus on what you can control, because that's where the power lies.
The Dalai Lama has a saying that in the face of anger, justice evaporates.
If you can't focus group it, you have to be very, very critical of your process.
The facts aren't good, you can't create a miracle.
We can agree to disagree and be zealous advocates for our clients.
Quit worrying about looking perfect. You're not going to. That'll come in time, but you can still be an effective litigator.
Welcome to the award-winning podcast Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Welcome back to Trial Lawyer Nation. Today I have my partner, Malorie Peacock, and we're going to talk about some of the things we learned from putting on our Big Rig Boot Camp. Both, we want to talk about some of the substantive law things that we learned in researching and preparing for the presentations we gave that we think may be helpful to other lawyers, but also some of the things we learned in putting on the online presentation that may be applicable and helpful for Zoom trials and even Zoom hearings. I personally hope we're not going to have Zoom trials, but I know, we don't know what the future is going to hold, and at some point a court may order us to do it, and we want to talk about the best ways to do that. So how are you doing, Mallory?
I'm doing good. We're coming off a big high from last week from that presentation. It was pretty awesome. I mean, we had, I think, up to 200 people watching, which was really exciting, but it was a lot of energy and a lot of effort, especially for you, to put that on. So, playing catch up and.
Yeah, it was a lot of fun. For those of you all that didn't join in with the Big Rig Boot Camp, it was, trucking specific, but it was a 6-hour seminar, and I was the only formal speaker, although we did have we used Cameo and had a lot of celebrity guest appearances, basically, because Cameo allows you to pay a celebrity to record a message that you can then play. And then I don't know how Delisi Friday, our marketing director, finagled this, but she got David Kushner, I should say, from the Anchorman in The Office. He's a comedian and actor. She actually got him to do a live feed and appear, and that was a lot of fun. Not necessarily law related, but if you're going to have a 6-hour virtual conference, you got to keep people awake and engaged and entertained.
Yeah, and I think there's two really amazing things that happened at the seminar. One was that you spoke pretty much straight for almost 6.5 hours, which takes a lot of energy and a lot of stamina. I mean, it was a lot of speaking and presenting. But then the second thing that was really cool that happened is that we basically kept our audience for the entire 6.5 hours. And you would think through Zoom, we'd lose some people throughout it. But I think a big part of it was your presentation style and then the way we put it together, which is why I think we can learn something about Zoom trials from the presentation you did.
Yeah, well, one thing we did that I think really helped is we had we spent the money and got a professional film crew. So we had 2 cameras, which meant we could do multiple camera angles. We could easily switch from, just me talking to me talking in the corner with the screen and me knowing where I am in relation to the screen so that I can look at and point to the screen, and it looks like I'm looking at and pointing to the screen for the viewer. I think those things really help. And I think that, the ability to stand, although my feet did hurt, starting about 4 hours, the ability to stand makes such a difference in gesturing and body language. It's really hard when you're just seated in a seat to really, express yourself, get out there. And I think that, we should think of it for big hearings, but definitely if we had to do a Zoom trial, instead of just sitting in front of a webcam, having someone else with a camera that can follow us around, that can allow us to stand and gesture, and even use exhibits, use posters, interact with things, is going to be crucial.
Yeah, I think, I have noticed that whenever I do Zoom hearings, I feel like my energy is lower, but part of it is because you have to sit in one space a small space so that you can stay within the Zoom screen, for the entirety of the hearing. So I sit, I mean, I don't really have a place set up where I can stand, but seeing you do that, I'm kind of thinking about somehow rigging something like that at home so that I can stand for hearings, because I think it would increase my energy. But the hand gestures, I think, it's part of the way I speak anyways. And so something is lost without that.
And it's a really important part of nonverbal communication, and judges are humans too. I mean, they get a lot from nonverbal. David Vall actually circulated a paper in opposition to Zoom trials, and the research was that jurors get a lot from nonverbal communication. Nonverbal communication is an important part of human communication, and because people are just sitting there in front of a screen, we lose that, and it's one of his reasons for not wanting to do Zoom trials. But I'm really thinking that, once the COVID numbers in Bexar County, hopefully they continue to be down when we release this in 13 days. But right now, we've had 2 weeks of, very reduced cases. Things are on a downward trend. I'm hoping, if we can get back to at least some of us working part-time in the office, that we could, work up a little Zoom studio where we have a little, okay, here's where the camera is. It's going to be from the waist up. We know that we can move. We know that we can bring a poster if we needed to or something to help with that. And then maybe even, for a really, really big hearing, work with someone else to do the audio visual, and, just to give an option to give better presentations to the court. Because I think that, the Zoom screen share works. It's not bad, but if we could do something, to keep the judge awake and engaged, and then definitely if we're going to do a jury trial, we've got to keep some way to keep these people interested. We're not going to be able to play funny celebrity videos during the trial. But I mean, I think the switching camera angle, so it's not always the same camera angle, is really important. The movement, the body language, the use of visuals and actually interacting with the visuals was all really important. And I think if we're going to have a jury trial, I think we're going to just have to invest in the money to find a way to get, someone to film us better, and then figure out how to get that to feed to the court Zoom, so that we can present our case in a more persuasive, entertaining, engaging manner.
I was surprised at how big of a difference changing the camera angles and changing the view made. I mean, honestly, when DeLisi said that they were going to do that, I was kind of like, oh, well, that'll be nice, but I didn't really understand what the benefit would be. But when I saw it in action, basically she changed the screen view at least every minute, right? So almost every minute we're moving the speaker to the bottom corner. We're putting up a slide. We're putting you back in full focus without the screen. So constantly changing it, it kept you engaged, and it didn't feel like you were just staring at the exact same thing for hours and hours. So actually that made such a huge difference, and to me, surprising.
I've not been able to make my schedule work to go, but I know a lot of people that have gone to the Mark Lanier Trial Academy. And one of the things he does, for those of you who don't know Mark Lanier, he's an absolutely brilliant lawyer, multi-billion-dollar verdicts. Part of the advantages of having that kind of success is you can really do things first class because you're working on mega cases, so you can spend mega resources. So he does a 3-camera setup when he does a depo, 1 camera on him, 1 on the witness, and a document camera. And then when he's presenting depo clips at trial, he ensures that he spends no more than 7 seconds in any one view. And the reason he says is because if you look at TV, they're always switching the view. They never show a view for more than 7 seconds. And ever since I saw that, every time I watch a news interview or something like that, I start timing it. And it's true. They don't ever, even if someone's giving a big, long answer, they still switch views during the answer. And I think it's just to keep you engaged. It's so easy just to drone off when you just see the little talking head. And I think that's some of the Zoom fatigue I don't know about you, but I'm getting huge Zoom fatigue.
Oh, yeah. I just feel like I'm on Zoom constantly. I've already been on Zoom for like 4 hours today. And I just feel like it's never ending. But part of it is you're staring at the exact same thing in the exact same screen for hours. And, to keep a juror's attention in the courtroom when there's absolutely no distractions, they don't have their phones, they don't have anything else. All they can do is stare outside, maybe if there's a window. it's still hard to keep their attention. So I can only imagine how much harder it's going to be unless it's something truly dynamic and something that you can keep them interested in, and so it feels like a movie almost, or a TV show.
Yeah. So if we do have to have a jury trial or, working with an evidentiary hearing with Zoom, I think it's really important to think about, how can we be regularly switching it up? Either having a camera where someone can stand and articulate and use gestures. How can we bring in exhibits, both slides or even a physical poster, a model, or something that someone can use to show the judge or show the jury. But think about how we're going to constantly be changing the visual as the presentation goes on, so that people just don't, tune out. With Zoom, it's so easy for them just to open another window and be surfing the web. You can't even tell. It looks like they're looking intently,
Right.
and they're reading TMZ or the news or YouTube videos or something else while they're going.
Yeah, and so with that, I think it's not just the visual, but it's the energy that you have to be able to bring to the Zoom platform to keep people engaged. So it's not just what they're looking at. And honestly, I was telling you earlier that even the slides that had very little on them, 1 or 2 word phrases, as long as you kept your energy up, it was still engaging for people. And so can you talk a little bit about how you kept your energy for 6.5 hours of speaking?
Well, part of it is just like being in court, where you can be absolutely exhausted before you start the day. You can almost collapse when the jury walks out of the room, but when you're on, you're on. And part of it is when I'm on. And, it's easier with a live audience, I'll be honest. But, I've just imagined a live audience. And, once I was there, I was on. I had not had a lot of sleep. I was up till 3 a.m. and then got up at 6. So for 2 nights in a row. So I was fatigued, but, the adrenaline hits and you just go. But with energy, the other thing is you can't be high energy the whole time, because then you're just manic, you're frantic, you're going to stress people out. And then it just becomes background noise and they tune you out. So it's the management of energy. It's the purposefully going up and then down and then up and then down. And, having a range of vocal inflections, a range of pacing. Some of that, it wasn't totally conscious. Some of that was the slides I used. So some slides had big quotes. And so then I would turn to the slide and I would read the quote, and that would be a lower energy slide, because then they're focusing more on the slide and not on me. Or even, I've got the little breaks when I got to play video clips. You play a video clip, then you can turn it off for a little bit. But then when there's a slide that just had a couple words on it, was just kind of, telling people, giving them a reminder of what I'm talking about, then I had to be higher energy, because then it was on me. So it's just that constantly kind of changing it up and thinking about what your flow of energy is going to be. And it's important during a trial too. I mean, you've got your rules. That's going to kind of be a medium energy thing, like an opening statement. Then, your teaching is going to be high to medium energy. And then you've got your story that's going to start off lower and then get higher and higher towards the climax. And then you got to drop off a little bit again, and you go to who you're suing and why. And, that's more of a medium energy thing. So, you're just going up and down on stuff. And it's that contrast that really gets people interested. I'm still working on mastering it. I've been working for a little over a year, I guess, with Sari on that kind of stuff. But it really, I don't know how much you've noticed it, but to me, it really seems to have made a difference.
I think it made a huge difference. And I could tell, because I've also worked with Sari, so I can kind of pick up on some of the things that she's taught you. But also I've known you for a long time and seen you do a ton of presentations. And so I can tell the difference from before you started thinking about these things. But I mean, energy management is such a complex thing to me. I have trouble figuring out when it should be high energy, when it should be low energy, when we should be calm. I mean, I have a natural tendency to speak loud and quickly, just because that's sort of my natural tone and my natural voice. And so I guess making myself stop doing that has been a real challenge for me. And I know you have a natural tendency to also speak really quickly. How have you kind of managed slowing down? What has helped you figure out a way to slow yourself down and maintain high energy?
Well, what really started, this is probably 15, 18 years ago. I was trying a case, which I thought was a slam dunk. I actually thought this was one of the cases that was going to put me on the map. Rear end collision, great venue, trucking case. And I thought I had the case in the bag. The defense lawyer thought I had the case in the bag. The bailiff thought I had the case in the bag. And after, by closing, the court reporter said, "You're going to lose this case." I'm pissed. I'm like, "What the hell are you saying? I'm going to lose this case?" But you're going to lose this case. You talked too fast. The jurors had no idea what they said, what you said. They couldn't follow you. You're going to lose the case. And lo and behold, they wanted me to win, but they initially put that the truck driver was negligent and that he was in course and scope, so the company was liable, and they put the damage amount. But then they felt sorry for the truck driver, and one of them said, "Look, if we just leave question number 2, the company will pay, and we can." They crossed out yes and wrote in no on negligence on question number 1 because they wanted the company to pay and not the truck driver, and which was a 0 verdict. Luckily, we got a new trial, and it worked out. We still ended up settling it because the damage number they wrote in was a lot more than the offer, and the defense lawyer didn't think it was going to happen twice. So it worked out, but it taught me an important lesson that even if I couldn't get out everything I wanted to say, slowing down so that, making the talk about the listener and not about me and what I think is important. So I think that was a big thing. The other thing has really been a mindset change. So and really, I used to think that it was my job to win the case, which sounds like, of course it's your job to win the case, right? But it's not, because I don't have the power to do that job. I don't have the power. I don't make the decision of whether we win or not. I decide whether I'm willing to do the work and put in the effort to give us an opportunity to win. But the jury decides who wins and who loses. It's my job to guide them and provide them with what they need to do justice. I need to provide my good jurors with the ammunition they need to go back in the jury room and argue the case for me. And with that mindset, then what's most important is not me getting out everything I have to say. It's me ensuring that they understand it and they're able to articulate it. And learning to, make eye contact with people, make sure they're getting it. Did you get that? Look for the little nod. If not, go back. Has really helped. And just being conscious of the fact that I talk too fast.
Yeah, I think that's always the first step, is recognizing the problem. At least for me, that's been a big step for me, is recognizing that I do speak very fast and I speak very loud. And it can be, if I'm especially in front of a jury and I'm right in front of them, it can be too much. Like it's too loud right in your face. And so managing that and recognizing that it can be a problem is the first step.
I never would have thought I used too loud. That's interesting.
I've only had a few people say it to me, but I think part of it is I'm not very good at, when I get excited about something or passionate about something, I get louder and louder and louder, especially when I'm telling a story that's interesting to me. When I'm telling our client stories, those are interesting to me. So I get louder and faster and more passionate about it. But if I'm passionate and I haven't gotten the listener there yet, it doesn't translate. It just feels loud and abrasive, as opposed to they're right there with me. They're just as excited about it. I get too excited too fast, I think.
And that's the problem, is that we're too into what we're thinking and what we're feeling. And we need to be thinking, how can I tell the story in a way that's going to elicit that feeling in them? What is it that made me feel that way? Well, it wasn't someone telling me this excited story. It's just me getting all these pieces and putting it together and figuring it out. And then you get that aha moment and then you get pissed. And, so I think sometimes we have to turn it down a little bit. And there's a time for passionate advocacy. I'm not saying that we never get loud, that we never, argue passionately or teary-eyed, because I definitely do that. But it's timing. You got to get them there first. You just can't start off, you start off your opening statement, I just killed my client and he was such a good person, and start crying, and you're going to turn people off because they're not there with you. I mean, really and truly, if there's someone you don't know and they just break down crying, you don't really want to go talk to them and find out what's wrong with them. You're just like, oh my God, I got to deal with this person, and it's just, meeting the jurors where they are. But it's a mindset thing, and changing my mindset. I think that's why I've done so much better since I read Carl Bettinger's 12 Heroes One Voice. I think that's what it's called. His book on the hero's journey, how to try a jury trial, because it freed me from my thought that I had to somehow win the case. That my job is to guide the jurors towards winning the case and to really reverse roles with the jurors, which I should have got that from Trial Lawyers College, but I was really too busy reversing roles with all the other people and not the juror. And so I think that has really helped me slow down. And then, working, even then the management of energy, I did not, no one really talked to me about that much before Sari, to be honest with you. So it's something I'm really getting from working with her.
I mean, honestly, before she talked about it, it's not something I had really considered. But I remember one time, I don't remember where we were, but it was me, you, and Sonia and Sari, and we were in a hotel room, and you were practicing something.
Yeah, let's be clear. We were practicing.
Oh, yeah, no.
I had a speech the next day.
Yes. No. We were practicing. You were practicing your speech, and Sari was there, and so she was giving you feedback. But she was really telling me and Sonia, she said, think about how you're feeling about the speech, right? And when you get really passionate about something, if me and Sonia weren't there yet, we would start holding our breath. And then Sari would point it out to us, and I didn't even realize we were doing it. And she was like, see, you're not breathing. And it really got me thinking more about energy management. I mean, I just never thought about it that way.
Yeah. I wish I knew how to articulate it yet. I just know that I can't stay high energy the whole time. I have to go up and down, and I have to try to bring my audience there and not assume, that they're going to be where I am before I start the speech or start the trial. And it's an ongoing journey of learning and discovery. That's all I can say.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach DeLisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowen to speak with you in person or by phone to discuss the case in detail. And now, back to the show.
So one of the other things that I think helped with the presentation, but I also think it helped with the management of energy, is the different kinds of slides that you use throughout the 6 hours. I mean, I guess I would classify them into a few different kinds. There was a kind that's like a teaching slide where it has a regulation written on it and certain pieces highlighted and summarized, and it's very busy and it has a lot of information. So that's sort of like a learning slide. Then there's just sort of like a topic slide that just is you're talking and there's just a reminder about what the subject is for the audience to watch. And they were just sort of almost blank slides, except for like a little phrase or a little topic or a little quote to remind people what the goal was. And then there were just sort of transition slides, like here's what's coming, not necessarily something you're talking about now, but just preparing people for what they should be looking out for in the future. And that really helps you with management of energy, because you knew that the almost blank slides are the ones where you needed high energy, and the ones with a lot of information, you needed lower energy because you need to give the audience time to read it and digest it before you start talking about it.
And then you've been in trial with me. We actually put in all black slides so that there's nothing appearing on the screen when we're trying a case, so that when I want the jury 100% on me, I don't want a word on the screen. It's a little different on a video screen because they can look at the word and at me at the same time because you can do the picture in picture. And it gave them something to break it up. But in trial, during the pivotal, like when I'm talking about something pivotal and emotional, I don't want to have the word, mental anguish or love or something like that on the screen, because are they looking at the screen? Are they looking at me? What are they supposed to look at? So during that point, I want a black screen. And then, if I want them to look at something, I need to be looking at wherever I want the jury looking, I need to be looking. So if I have like a picture of the let's say it's a death case and someone passed away, and I have a picture of the widow and the man who passed away. Well, then I need to go look at that with the jury so they know where I want them to look, and that we have a shared experience we're looking at together. And then I should take it off. I shouldn't necessarily leave it on the screen because, again, if I leave it on the screen, are they looking at that? Are they looking at me?
Yeah, it can be confusing. And I think people do that too much, as they have too much busyness behind them, and then the jury doesn't know what they're supposed to be doing. Are they supposed to be reading what's behind you? Are they supposed to be listening to you? Are you even talking about the same thing as what's behind you? You really have to think about that when you're giving a presentation, and especially an opening or a closing.
I think a lot of us use PowerPoint, and I will confess that some of those 2-word, 3-word slides were done for this reason, because I was speaking for 6 hours and I needed to remember what I was going to say next. But I think a lot of us use PowerPoint as our outline, or as our, almost like our speech, and we put way too much in there. Whereas if we would just practice or have a little outline that only we could see, put up somewhere, like, print it out like poster size and put it where the jury can't see it and you can, like right in front of the jury box or something. It would allow us, I think, to keep organized but present better, because again, our presented as a title, like, okay, now we're going to talk about this, and you look at it. Now we're going to talk about, pain, and then take off and go back to a black slide and then talk to the jury about pain, because if they're reading the word pain or they're looking at different pictures or different graphics while you're talking, it distracts from it. Whereas, if I was doing a Zoom trial, I might want something up. I want something, but I want it where it's picture in picture. I know where it's going to be in pain, and then I can be pointing to it. Now we're all looking at this together, and this is what this shows. Because without the human interaction, I may need to have more visuals. I think if we ever do a Zoom trial, we're going to do 2 or 3 times as many visuals.
Oh, yeah. I think you have to. I think you almost have to constantly have something that could be a visual, just so that you can be changing the camera angle to keep the screen dynamic and interesting to the juror. I think you'd have to have a visual for almost every second of what's going on.
Yeah, if I had a Zoom trial of any consequence, we've consulted with so many theater people for trials. If you look at a lot of the consultants, David Ball, Josh Carton, a lot of the consultants come out of the theater world, which makes sense because, the trial is a live, in-person, interactive event. If we ever go to Zoom trials, I think we really need to talk to movie, film, and TV people and get them to help us put our presentations together, because they know how to tell. People can do a 20-something minute, a 30-minute TV episode. There's 24, 21 minutes of actual content. And people can tell a story of a trial and make the viewer want it to come out a certain way in those cases, in those shows. So, how do they do that? How can we do that? Now, we can't do it in 21 minutes because we have to put on more witnesses and we have to meet all of our evidentiary burdens and everything. But getting them to show how to engage people on the screen, I think is going to be really important. And I think the other advantage is, at least on a big case, I think our side is more likely to spend the time and money to do that than an insurance company. So I think an insurance company's probably have them stuck behind a laptop, computer, or just a regular webcam. I think we may be able to just really overwhelm them on having a better visual presentation, at least at first.
Yeah, I think too, by preparing for a Zoom trial, we could be better in person in court trial attorneys too, because it really gets you thinking about visuals and the way that you're coming across. And I think every lawyer, myself included, sometimes has things go on too long.
Yeah.
People testifying, witnesses, even opening or closing, sometimes it just goes on too long. You've said it, you don't need to keep saying it, they get it. And so with Zoom, we're really going to have to be more judicious about that, because you're only going to get people's attention on Zoom for so long. So you don't want a 5-hour witness if you can avoid it. You're going to want to have it as succinct and as clean as possible. And that goes into preparation as well, though, because, if you're going to play a deposition, you need to go into that deposition thinking, I need a 10-minute clip out of this 3-hour deposition. How am I going to organize this so that I can get that testimony in a short, easy to understand way?
Yeah, my experience, when I have long deposition clips, it's when I've put off the task of editing till the last minute, and I'm just going through and making one run and handing it to someone or doing it myself the night before. When you really think about things, you start with a jury charge, and then you do a root cause analysis. Before you do a depo, you have a plan. This is what I want to prove, and then you stick with it. This is my best case. This is what I want to prove, and I'm going to resist the temptation to get drawn down all these other rabbit trails. And I'm going to put on my case, and then I'm going to sit down. You have a better, more coherent, tighter trial. But also working with graphic artists, and you don't have to work. Companies like High Impact do beautiful work. I mean, I don't want to, and we still use them for medical exhibits, but they're expensive. You can, I think the best thing we've ever done as a firm is we hired a graphic artist. We did it for our marketing department, but he also works with us on cases. And you don't have to have a full-time graphic artist, but if you go to Upwork, you go to lots of different places, you can find graphic artists that will work on a contract basis for a lot less money than legal exhibit companies. And get that, what you're trying to do is convey a message, not make something that's really pretty and snazzy. You can really create some really simple graphics that really help you with your case. And I think with witnesses, the more we can bring in visuals, bring in photos, bring in videos, the more interesting they are, and the easier it is to keep the jury, because they get a little bit of testimony, then they get a visual look at, and a little more testimony, and let's watch a video, then a little more testimony, and it keeps them engaged and active.
Mm-hmm. Yeah, I will say too, for the audience that feels like they can't spend much money, a lot of the trial visuals that we used in mine and Michael's last trial, I created through PowerPoint. So if you really cannot, spend a lot of money, these things can be simple. They don't have to be complicated or beautiful to get your point across. You just have to think about, what is the point I need to make with the visual, and then make that point and leave it alone. You don't need it to be complicated, and you don't need it to be, a bunch of colors or a bunch of complicated graphics. I mean, you can do stuff through PowerPoint too.
And actually, a lot of colors and complicated graphics sometimes detract, because we're doing an internal training session, and we had our graphic artist do my first PowerPoint, and I got it to him late, so I didn't get time for a lot of feedback. And some of the things he did were really cool, but some other things he did, it was too busy, and it was too hard to say, what am I supposed to be reading? And the ones I've done myself, which are much simpler and don't look as pretty, I've gotten better feedback on, because it was very clear that this is what I want you to read.
Yeah. Being clear with the jury of what you should be taking away from the slide or the exhibit or the poster is really critical. And not almost always, we show our graphics to people who are not involved in the case and are preferably not lawyers. So you can say, what do you get from this? What do you see here? What are you looking at? And if they don't get it pretty quickly, then you need to change your graphic. It's not useful.
And we've done that before. We've created graphics and we've sent them around and realized that, it does not convey the message we think it conveys. And we have to explain it. If you see a graphic and a person thinks one thing, and then we're having to try to convince them it really says something else, then we're losing. I mean, why should we ever put something in front of a jury that doesn't help us? As far as if we're creating it. I mean, sometimes I know you have negative evidence, you got to get out there and massage it. But if we're creating the exhibit, it should, from the very first glance, support our case. And a lot of things that, and things that I paid a lot of money for. I had someone create a visual for me showing, because he had a lot more treatment before than after with an aggravation case. But they decided to put in like a needle, an injection for every ESI the guy had epidural steroid injection before. And it made it look like he had a bunch of painful, invasive treatment before the crash, whereas a simple timeline was a much better exhibit. And so we ended up spending money on that and then not using it, because the graphic actually hurt our case. I was so mad. Like, how could you give me this? But, they don't, they put themselves out there as, we're courtroom persuasion experts, but they're not. They're experts at making pictures.
Yeah, and I think that there's been a real mind shift change for me in the last year or two about my role as the attorney. And we're here to get the information to the jury in the most easy to understand way possible that supports our case, of course. So we're advocates, but we're also storytellers. And if your story doesn't make any sense, you're going to lose. And so everything that you put effort into should be towards that end, creating a simple story where you win. It doesn't have to be complicated. And just because we're lawyers doesn't mean it should be complicated. I know a lot of lawyers overcomplicate things because they're lawyers and they feel like they need to earn their money or something.
Yeah, you can't win a complex case. Every case deep down is a simple case. It's just, way back when Joe Jamel tried Pennzoil versus Texaco or Texaco versus Pennzoil. I don't remember who he represented, but I know he got a multi-billion-dollar verdict, and it was this really complicated oil and gas deal, and he turned it into, does a handshake mean anything? If you shake on it, if you made a deal's a deal, and people got that. That made sense, and that's really what the whole case boiled down to. Is they had a memorandum of understanding, they had a handshake deal. Is that enforceable or not? And I think had he gone into all the regulatory stuff and email, actually back then it probably wasn't emails, but communications back and forth, and, just make a simple story. And, even product cases, usually if you can win them, turn into a simple story, They knew this roof was too weak, but they put it out there anyway. They knew seats collapsed backwards and were in collisions, but they made them anyway,
I know we've been in that position before too, when you have paid people to create animations or, complicated models of the wreck or what happened, and then you show it to a regular person and they think it proves the exact opposite of what we thought we were proving with this great animation and this great visual, or there's something totally distracting on it. Like there's like a weird signpost or a weird tree, and then the jury thinks that's something important in the case, when in reality you just take it out and throw it away. It doesn't mean anything.
Yeah, sometimes they get too into providing all the little background details, and it's distracting. People are looking at the flowers and the trees and the bushes in the background instead of at the cars. And sometimes a simpler, more scaled back animation works better, and sometimes, frankly, 2 toy cars work better than animation. And you don't have all the admissibility issues either. We've really gone, I think, in the last 2 or 3 years from, I think we're spending a lot less money with the professional exhibit companies and going to much simpler exhibits that really seem to be getting the job done as well or better for a lot less money.
Yeah. No, there is a place for complicated exhibits or animations or to spend money on things. I mean, it's not to say that there's not value in some animations or some big 3D scale models or, stuff like that can get expensive. I mean, there is a place for those, and they can be very valuable and very helpful in cases.
Yeah, we just did a 12-foot long 3D printed roadway to show all the different signs that over half a mile that a driver passed by because he was distracted before he ran a stop sign. I just did where someone had like 20-something broken bones. I paid High Impact a ton of money to show all the broken bones and surgeries and stuff like that. But for a lot of our cases, we're able to make some very simple things in-house that communicate the damages, but save our clients, thousands or tens of thousands of dollars without any lesser result.
Thank you to everyone who attended Cowen's Big Rig Boot Camp in August. We had an excellent virtual turnout this year and are already thinking of how we can continue to raise that bar for next year. If you'd like to attend virtually in 2021, be sure to mark May 20th, 2021 on your calendar now and save the date. To stay updated with details as they become available, visit bigrigbbootcamp.com and sign up for our mailing list. And now, back to the show.
So, for the webinar itself, you have been, I think you've talked about it a few times on your podcast. You've been working on writing a book about trucking law, and it's coming along quite well. I've read some of the chapters. They're very good, I will say. So people are going to be excited once they get it. But in that vein, the webinar, the subject was trucking, and you chose what you called cutting edge topics, a few of them, which are things that you've done a bunch of research on recently. And I thought that there were 2 that were particularly interesting that I think your audience might be also interested in. And one of them was about electronic logs. So for the audience, what's kind of the background of electronic logging in trucking?
Okay, sure. Well, logging is when a truck driver says whether they're driving, whether they're in the sleeper cab, whether they're off duty, or whether they're on duty doing something other than driving. And the reason it's important is that a truck driver can legally work a 14-hour shift and drive. The basic rules, they can work a 14-hour shift and drive for up to 11 of those 14 hours. And in an 8-day work week, they can work up to 70 hours. And after that, they have to stop driving. And you would think that's a lot of hours, 70-hour work weeks, 14-hour work days. But because truckers are typically paid by the mile, and they have a lot of time where they get stuck at shippers, they get stuck doing things where they either can't make the delivery, or more importantly, they can't make a living because they only end up with 2 or 3 hours of legal driving time because they get stuck so many places, that they would cheat. They used to have paper logs that would keep track of all on paper, and they would cheat, and they would say they were sleeping when they were driving, or sleeping when they were, doing, or driving when they're not driving. They did all kinds of crazy stuff, and we'd catch them. It'd be really easy to catch them. It was a lot of fun, but it was such a safety issue that starting in 2017, the government requires all 18-wheelers to have what they call electronic logs. The way electronic log is if you're driving, the computer will automatically record the vehicle is driving. So the driver should no longer, in theory, be able to say, I'm in the sleeper cab or I'm off duty when I'm really driving. And so, the thought was, well, this is going to end all these issues. But in doing all my research for the book, I found a bunch of ways that truck drivers can cheat and still work more hours than legally allowed and hide that from from the government, from us, and sometimes from the employer. Sometimes the employer has to be in on it.
2 questions. Why is there such a culture within the trucking industry of trying to cheat on logs? I mean, why is that such a big issue that they had to mandate electronic logs to prevent people from cheating?
Yeah, because they really put, the truck driver is viewed as a freedom thing. Who are they to tell me when I can work, when I can't? I know my own body. But it's really the mistreatment of truck drivers by the trucking industry. Because they're paid by the mile and they're not paying for all the time. I read a study by the American Transportation Research Institute that when they go to pick up or deliver a load, on average, they're stuck 3 to 4 hours. They can be stuck as much as 8 hours. So that's 8 hours, 3 to 8 hours of on-duty time, eating against your 14-hour day, eating against your 70-hour work week, but you don't get paid for it. All the time they spend doing paperwork, when they have to go get the vehicle fixed, when they have to do inspections, they don't get paid for any of that time. When they're stuck in traffic, what they're making per hour goes way down because they're going slower and they're getting paid by the mile. So it is a really unfair system for truck drivers. And the only way they can make a decent living, despite all the hours they're working, is to cheat and work more hours than legally allowed. It is a sad state of affairs. If they would pay them by the hour or pay them a salary, which is something the government encourages but doesn't require, that hardly anyone does, that would change everything. But right now, they're under pressure to deliver on time. They're only paid when they're driving, and that puts pressure on them to drive when they're not legally allowed to drive and when it's not safe to drive because they haven't had enough rest.
So I've done a ton of trucking cases. I've never come across a long-haul trucking company that paid its drivers by the hour or a salary or anything like that. It's always by the mile. And the only time I ever see it, paid by the hour or a salary are usually sort of local truck drivers, at least in my experience.
I think I've only seen 1 or 2 that don't pay by the mile in the long haul. It's very rare. Yeah. Because it's better for the trucking company. And look, the trucking company would rather, from an economic point, if the driver can only drive that truck 2 or 3 hours that day, that's only 2 or 3 hours of income because the trucking company is getting paid by the load. They're not getting paid by the hour. And so, economically, they would rather have that driver have an incentive to cheat. And a lot of this, it's not just drivers doing it, it's dispatchers know it. Dispatchers are pushing it. And, if we go into how they cheat on the electronic logs, it's very easy for a trucking company that wants to catch them to catch them. but they have to care about it and not look the other way. And unfortunately, the stories I've heard from truckers are that they're being encouraged to cheat because the trucking company wants to get the load there on time.
So I don't want you to give away all of the things in the book, but what are some of the ways that that you found, just based on your research, that they're cheating on these electronic logs with the computers?
Well, there's a few things. One, there's something called personal conveyance. And so let's say I'm off duty. I stop at the truck stop and I decide, I want to go drive and have dinner somewhere during my off duty time. And so I'm going to drive the truck to a restaurant, eat, and drive back to the truck stop. Well, that's not on duty time. I'm not driving a truck for the company, so I'm allowed to do that. Or if I want to go drive to my sister's house, because I just happen to be in the same town as my sister. So I'm going to drive to my sister's house, go hang out there, and then drive back. Even if my sister lives an hour away, that's still not considered on-duty time. So they have something called a personal conveyance, where you can tell the thing, I'm in a personal conveyance, and it will allow you to drive but log it off duty. Now, a personal conveyance, you cannot be working on behalf of your employer or moving the load on behalf of your employer when you're doing it, but it's the way they do it. I'm going to drive my first hour in personal conveyance so I can get more time today. Or I'm going to drive to the loading dock on personal conveyance, and then I'm going to stay off duty, not driving, when I'm there, loading when I should be on duty. And so, the hour I spend getting there, I'm going to have personal conveyance, and then I'm going to spend 3 or 4 hours there being loaded, and I'm going to leave that off duty. Now I've got 5 hours that I've logged myself as off duty. I've counted as towards my 10-hour rest. I've not gotten enough sleep, and then I can start my drive time. So that's one big way to do it.
Does it show up on, like, if you get an electronic log printout, does it show up as personal conveyance, or how would you recognize it?
It may or it may not. So what you want to look for, one, you want to make sure you're requesting, and it's something we're working on revising our discovery after I've done the research for the book. You want to request any personal conveyance time, any driving time that's not reflected, any what they call unassigned driving time, which is when they don't even log in and they drive the truck and then they log in later. But you also want to look at if the electronic log is set up properly, logging device set up properly, it should have a latitude and longitude coordinate from the GPS every time they have a change of duty status. So what you'll find is they go off duty one place and they come back on duty in another place. Well, you got to look at that and say, okay, well, how did they teleport from one place to another? And then start doing the discovery. Give me the documents showing me what was happening during these miles that this vehicle was driven. Although sometimes they're really smart about it. And one of the reasons you need to really, if you can look at there are documents that will give you mileage too. It just depends. You need to find out what system it is, get the user's manual, what reports can be run. Because another thing they'll do is, let's say they're staying at a truck stop that's, let's say, an hour from where they're going to do the pickup or delivery. And they know they're going to be stuck there for a while. And then they're going to head back the opposite direction where they pass that truck stop again. So they'll go stop at the truck stop, go off duty, do their rest, and then they'll drive either not log in or drive personal conveyance to the shipper or receiver. And then they will, or even unplug the logging device and drive to the shipper or receiver, get loaded up, drive back to the truck stop. So, 3, 4, 5, 6 hours have passed. Then they go on duty. And then they start their trip from the truck stop. But they don't pop around because they started and ended at the same place at that truck stop.
That's clever.
Yeah. And so also look at, if they have, they have a bill of lading showing they picked up or delivered somewhere, but the logs don't ever show them getting there. Things like that.
Do you have one more way that you'd like to share?
Sure. Another way. Now, the trucking company has to go along with this, but I've read a lot of stories of this happening. Is they'll create a phantom driver in the logging system, and the trucking company has to do this for them. They can't do it themselves. So they'll drive so many hours as the phantom driver, and then switch to themselves and drive so many hours. And so if we ask for their logs, we'll only get their logs, and it won't show the phantom driver's logs. And so they may even claim to us they had a co-driver because they'll have another name, in there. And so, anytime you have a report with a case where the police report only shows one person in the vehicle, but they have two sets, team driving logs, that's a big sign that something's going on there.
Well, cool. Well, I know there's a few more ways that you talked about in the presentation, but
at least 10, but I gotta give some reason to give trial guys a little money and buy the book when it comes out next year.
So I don't know if we have a little bit more time, but one of the other cutting edge topics that you talked about in the presentation that we just want to give people a little taste of is drug and alcohol testing. It was introduced by Charlie Sheen, which was hilarious. But tell us about what you talked about for drug testing.
Yeah, this scared the heck out of me. And actually, this research started on one of our cases where, we had a case where a truck driver on meth rear-ended our client. And he got arrested at the scene. And when we got the evidence photos from the police, not only did they find methamphetamine, but they found a flask full of pee. And I'm like, gross. Why? I mean, I've seen like the gallon water jugs full of pee because they just pee in them while they're driving, but I've not felt like a flask full of pee and the guy's belongings hidden. And then I found out that unless you've already tested positive and you're like in a program to see whether or not you can, safely drive again after testing positive as part of your rehabilitation efforts, when you go give a pee test, there's nobody in there with you. You're all by yourself. And so, yes, there are things they do. They measure the temperature. They look at, whether it's diluted, but there are a lot of ways to beat a pee test. You can you could pee when you're clean and keep it and then, warm it up and bring it in with you. You can get someone else's pee. They actually sell powdered urine and you add water to it and then it has a heater. You add water to it and you shake it up and then it automatically heats it and keeps it at 98.6 degrees for a few hours so you can have it with you. And then there's like cleanses and stuff you can drink that are, some are more effective than others on helping you beat a drug test. And so, I'd heard there are ways to beat them. I'm like, well, how much could this really be going on? Well, there's another way of doing drug testing called hair follicle testing, where instead of doing a pee test, they pull out a hair, and that usually tells whether you've done certain kind of drugs, usually in the last 30 days, which unlike a pee test, I know marijuana can stay in the system for a long time, but like cocaine's only there for metabolites for a couple of days, methamphetamine for a couple of days. So a lot of these guys, if they just stay clean when they know they're going to have a drug test for a couple of days and then go back to using, they'll be okay. And so a number of the bigger trucking companies went to using hair follicle testing on top of the urinalysis. And, what they found is just in their companies, I think it was like 12,000 something drivers that passed the pee test that failed the hair follicle test.
Oh my God.
And then they hired the university, some researchers at the University of Central Arkansas to say, hey, we've got a sample of, I think the sample was a little under 200,000 drivers. And they said, can we extrapolate? Is this population representative of? And they looked at it and they said, yes, your population is representative of the drivers. And based on this, we estimate there's about 310,000 truck drivers on the road today that have used drugs in the last 30 days and would fail a hair follicle test, but yet are able to work the system and drive under our current testing regime.
Wow. I mean, I just can imagine how people would feel if that number was like commercial airline pilots that were on drugs flying airplanes. I mean, I think people don't think about it in that context, but they should, because these things are huge and can kill people.
Well, they kill people in airplanes too.
Right. But I mean, that's, I think people would be more shocked or horrified if they found out there's three.
Congress has been mandating that the government come up with an approved hair follicle test that will be, because right now they're allowed to do hair follicle testing as an optional test, but it can't replace the pee test. They still have to pay for the pee test and do the hair follicle test. So they've been ordered for years by Congress to come up with a test method that would be approved so that the carrier could at least have the option of doing either one. But they've never gotten around to doing it. So meanwhile, we have literally hundreds of thousands of 18-wheeler drivers on drugs on our highways. It's insane. Of course, the answer is that motor carriers should start doing hair follicle testing anyway. If they know there's hundreds of thousands of these people out there, well then, spend the extra $100 or whatever it is and test for it. But unfortunately, most of them, with this driver shortage, are just, hey, that's how they drive those extra hours.
Right. Scary stuff.
It's scary stuff, but it's our job to catch it, expose it, and, put those companies out of business if we can.
Yeah.
Or at least make their insurance rates go up. Where it's cheaper, where it's cheaper to pay for a hair follicle test than it is to pay another big claim.
So it's my understanding, speaking of insurance, that they're trying to raise the minimum limits for truck insurance. I don't know how far along it's gotten. I don't think it's too far along yet.
It's a political thing. So the House, is it in the House version? I know it was in a House committee. I made it a committee in the House. I don't know if it passed in the House version or not. I don't remember. I think it may have, but then the Senate has to go with it, and they have to. So, but they have to just keep working on it. They've been working on it for a long time. I think it's gotten through the House more than once to raise the limit. I think to 4.3 million instead of 750,000 and index it to inflation. And the way they've come up with that is that, it was set at 750,000 back in 1980. And medical costs have gone through the roof. Other things have, inflation. 1980, gas was 25 cents a gallon or something. I mean, it's a different world now. And so they just wanted to index the original 750 to inflation to make it the same, today's dollars. We'll just have to see if that goes through. I don't think anything, I pray that it happens. I doubt it's really going to happen before the election. But it's, unfortunately, every time we try to do that, then other people try to say, well, this is only about trial lawyers. They forget about it's the victims that are suffering with these. You put somebody in a wheelchair, you kill 2 or 3 people in one crash. $750,000 does not go very far. A lot of times the medical bills alone are more than that. So it really messes things up. So hopefully they'll eventually do that. But a lot of that's going to have to do with who gets elected in November. Hopefully we get a lot of people. I don't care whether they're Republican or Democrat. I care whether they're pro-civil justice and how they are on our issues. And hopefully we get a lot more people in Congress and in the Senate that are good on our issues.
Yeah. And our issues are the issues of victims. So.
Yep. Okay. Well, everybody, wear your mask, stay safe, social distance, vote, and join us next time on Trial Lawyer Nation. Thank you, Malorie.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach Delisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowen to speak with you in person or by phone to discuss the case in detail. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, or contributors and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.